So starting Wednesday's class nanti you mark balik dah on the new December list ya. Please let me know if there is a problem with the list. If maybe you cannot put in your signature. Okay, so for today we will continue our discussion on online defamation. Can you see my screen?
Yes, sir.
Yes, sir. I can see, sir.
Okay, online defamation, internet defamation. I think this is a very hot area, so to speak. There are many cases on the rise now, especially concerning social media defamation. So in this topic, we will look at what is the meaning, what are the elements of improving defamation, whether it is similar with the real world defamation, and then we will see some of the developments as far as cases concerning online defamation, and there are, we will slightly look into the position of other countries like UK on how they handle social media, online defamation that is made through social media. From these topics onward, you may expect that, for example, like online defamation, we will start to talk about more legal, cases. Yeah, we will see how the this topic onwards will be more talking about the real social legal issues concerning cyber laws. So this part will be dia ada banyak case je lah. Tak adalah banyak sangat, tapi at least we try to see the recent happenings as far as the issues are concerned lah. So online defamation ni, we know that after we understand after we understood the how the internet works, and then because of the way it was designed, we know that it is open-ended, and then just anyone can contribute content online. What more in this this pandemic time, and I think even before pandemic time, we have user-generated contents, those YouTubers. I mean, it's already becoming a new kind of career, which people are looking forward to do this, and they have spent so much time to contribute content to the internet. So especially in this kind of what we call as user-generated contents, is an area whereby registration with the Ministry of Communication, or put it MCMC that way, is not required. So they are not like broadcasters. They are not like, if you look at the definitions of the application service provider or content provider, those two large category of service providers closely relate to broadcasting activities, or maybe they are large companies. They will have to be properly registered. But if you are just you're just a YouTuber, you are a normal content creator, no matter as the law stands at the moment, no matter how many followers you have, no matter how many likes you get on your Facebook or on your YouTube channel, you are not required by the law to register your business or your so-called service lah. So unless unless what you're trying to do is you're trying to be an online media platform, you are basically doing news reporting, that you may be required to be registered under the relevant laws lah. Tapi kalau macam the normal the ordinary YouTubers at the moment, they are not required to do this, and because of this we can find that the content online is there's a lot of false content, incorrect information, unverified information, suspicions, I think for the past few days since the decision of the case of Datuk Sri Najib, there's a lot of things, information, interpretations going on the social media. Some are positive, some are negative. So these are the dynamics of the how the information travels online, and basically we have also discussed in the earlier topic about whether everything should be censored or not, and then if you censor too much, then there'll be problems as well. If these are the challenges, and with the coming of all this high-speed broadband and all this machine learning, artificial intelligence, basically no one knows what we will be able to see in the next coming 5 to 10 years. That data or content, it may be manipulated in a certain way by this intelligent technology and so on, right? So because of this, we know that this false information or even can to a certain extent be defamatory information. It causes unnecessary worries, confusion, as well as misperception. So this again creates risky content online, and of course those who reads defamatory publications online, if they believed it immediately, then it will be, that's it lah. Meaning you will be swayed easily. I think this is also a problem, especially in our society, whereby people is very quick to share things because it's very easy to share. And then when false information tarnish reputation of individuals, so the consequences basically damage not just reputation, but also if someone is doing business, this is damaging for the business. What more if talking about country, the national image. So as far as under the Communication and Multimedia Act, we only find Section 233 as well as 211 talking about prohibition of prohibited content in the context of indecent, obscene, menacing, and offensive content. So the Section 233 doesn't spell out specifically that defamation content is to be prohibited under Section 233. But you can basically further use content code to interpret that defamatory content is not allowed under both CMA and content code lah. So under content code, you will find the interpretation of defamatory communication. They use the word defamatory communication. Communication here can mean social media comments, anything lah, as long as you communicate a message through network services. So defamatory communication can be publication, can be a web page, can be it can be a post, a forum, kan. So it is listed under the content code in the category of bad language, that devalues a person or group on the basis of race, ethnicity, religion, nationality, gender, sexual orientation, or disability. So defamatory communication ni, what kind of communication? Usually it is about it is describing strong language, crude language, explicit sexual references, or obscene gestures. This is defined under Section 6 of the Content Code. So specifically on defamation law, we have Defamation Act 1957. It does not define defamation, but we have seen that this is not a problem for the courts. It has been long defined under the case law. One textbook, Rogers here defined defamation is a publication of a statement which reflects on a person's reputation and tends to lower him in the right thinking, estimation of the right thinking members of society. So that is one definition. In applicable law, we know that for civil defamation, this will be covered under Defamation Act, but for criminal defamation, this is covered under Section 499 of the Penal Code. So the elements, of course, one is civil in nature. Another one is criminal. For the Penal Code, to criminal elements that needs to be proven. So tak sama lah, jangan confuse the Defamation Act. So usually people can take civil actions under Defamation Act, but for criminal defamation, this is usually be done by the public prosecutor lah. Okay, another defamation. Basically, I'm not going to repeat the discussion in thoughts. It's pretty the elements are pretty similar to thoughts. But what we will do here is that we will try to bring a closer attention to how the elements were being applied as far as the cyber or online defamation is concerned. So this is the latest element that was prescribed by, kalau tak salah, federal court ni, in the case of Ayub Saud and T.S. Sambatamurti. In this case, the court said that plaintiff must prove 3 elements. The words must be defamatory, the words must refer to the plaintiff, and note the word "and" here, meaning that all 3 has to be conjunctively proven. And finally, the words must be published. If the words are not published, then meaning the element is not fulfilled. Meaning you are just saying the defamatory word in your own room or in your own house, or maybe just within the circle of friends, but it is not published. We will talk about this publication element soon, because this is when the Section 114A of the Evidence Act is creating a new kind of treatment to the word published. Okay, so this is the 3, remember. So in other words, plaintiff must show that the statements bear defamatory imputations. I mean, the plaintiff as the person or the party that wants to prove that defamation has been done by the defendant, he must show that the statements has defamatory meanings or imputations, and the statement must refer to or reflect upon the plaintiff's reputation, not somebody else's reputation, and the statement must have been published to a third party by the defendant. So if it's not published to a third party, elements are not fulfilled. So what is the difference with online defamation? For the elements, you can see not much difference, but we can actually see that the court tried the court have been applying the similar elements or principles. But we can note some notable differences when dealing with online defamation. For example, here requirements of pleadings for cyber defamation is slightly different. For example, the URL and time and date of publication of the said website, the website that was said to publish the defamatory content should be pleaded. So specifically, it must be pleaded. You cannot. The court said that you cannot simply randomly, sue somebody for defamation, but you did not point to the court which URL, at which time, at which is the date of publication. It has to be quite specific, lah. Yeah. So the medium of publication plays a factor when assessing if a statement is defamatory. One example of the specifics has to be pleaded is this case, Lim Yun Min. This concerns failure to plead particulars such as URL, time of publication, and persons who had read the impugned statement. So this was a case whereby plaintiff sued the defendant for allegedly defaming them on Facebook. So in this case, the Sessions Court basically held that plaintiff failed to provide the complete Facebook web addresses and identify the parties that had read the statements. So the defendant here applied for striking out order. Striking out order is an order under the rules of court to dismiss the claim. Usually this is done at the early stage of the hearing in order to try to destroy the plaintiff's case. The reason why the defendant tried to strike out the case first was that they failed to state the Facebook URL on where the statements were published, and then the plaintiff also failed to state the exact time of publication, and the plaintiff also failed to identify or name the parties whom the defendants were alleged to have published the statements. They didn't even give the particulars of those parties who read the impugned statement. This is, I think, quite problematic. If you want to have access to this, can sometimes I'm not sure whether an ordinary user can actually have access to these kind of things unless you have to contact Facebook for the matter. Then. So the court here, instead of striking out the case, the court under Order 18 Rule 19 of Rules of Court ordered the plaintiff to amend their pleadings. So the case was accordingly amended. So you can see the principle here is that you need to be specific with where where the online publication is, and the court needs to know who would be the probable persons who have read the statements, perhaps as a matter of clarity. But the position in UK, as far as Twitter is concerned, we can see in these cases that as far as with the cases that for example Zahir, Monroe, Stalker here, they talk about defamatory postings that is very post yang pendek-pendek, very short kind of tweets to Twitter post. So sometimes these very short tweets, whether that and it is it is published on Twitter, so whether the court should indulge or spend its time to be overly analytical about something which is posted and can disappear within an hour. So the court in the UK held that that they should not be over analytical about postings on on a medium that is maybe similar to Twitter, something which is quickly read by the reader. People don't really give a careful thought about a tweet sometimes. For example, in Monroe, Justice Warby held that an elaborate analysis of a 140 character tweet is wrong. Meaning the court, I think, as far this is, we can actually try to understand that nak cakap satu lagi ni, yang stalker and stalker ni. This is also another case where UK Supreme Court said that the word "he tried to strangle me," which was posted on Facebook, should not be given a deep analysis on whether this amounts to crime or what. So it should just be read as an ordinary, reasonable reader. So in a way, if we can see the interpretations in the UK court is that if it's just short words or short character like tweets, maybe the court should not worry too much about interpreting these tweets to amount to crime or what. Tapi the matter may be different if we talk about a clear article that can convey a proper or a valid message. So that might be a different situation lah. So similarly, this was agreed, in this case. His Lordship also added, following Zahir case, people tend to scroll through messages on Facebook relatively quickly. They do not pause and reflect. They do not ponder on what meaning the statement might possibly bear. Their reaction to the post is impressionistic and fleeting. So this judgment, should be considered in cases involving publication on social media. But at the same time, our courts should also consider if the behavior of social media users in Malaysia is somewhat similar to those in UK. So we have to see the context lah. If the Facebook post is lengthy, able to convey a clear message concerning defamation or that sort, then maybe a different kind of legal principles may apply. So that's that's the position in the UK as far as whether we should give a really great emphasis on attention on the meaning of a tweet or not lah. So that depends on perhaps on situations. And the test for defamation, we know that the test to determine whether a statement is defamatory or not, first, as decided in this case, it must be considered what meaning the words would convey to an ordinary person. And second, it must be considered whether under the circumstances which the words were published, a reasonable man would be likely to understand that in a defamatory way. So the court concluded that defamation is a question of fact, and it has to be examined from circumstances of the case. So the court will have to determine whether, as a whole, if looking at the article as a whole, whether this is defamatory to the plaintiff or not. So that is for civil defamation. For criminal defamation, section 499 and 500 applies for criminal defamation. And of course, this clearly, when defamation happens, especially online defamation, it causes greater harm. The court has, in many online defamation cases, I think some of you have reviewed online defamation cases. the harm that can be caused by internet defamation can far exceed the print media, because the print defamation occurring in print media the circulation may be limited to a certain extent. But for internet defamation, this can happen in just split second, and then with the expansion of the internet worldwide, basically you never know how far the readership of a certain publication can reach. Yeah? So one example of a publication happening to a business. This is concerning a child care center. Yeah, so in this case, plaintiff basically sued the defendant for publishing a defamatory article on a blog. Yeah, the title was here, jangan hantar anak ke Taska Star Kids. Yeah? Don't send the child to Taska Star Kids. So this article basically talks about defendant. Plaintiff has dried and peeled off skin, contagious. Something that is defamatory towards the plaintiff. So the court here found that the statement regarding the plaintiff's skin was defamatory. Yeah? So in this case, the plaintiff succeeded in the case. Another case, Norashida, and Dato' Zainul Arifin. This was about Metro Online. Yeah? I think Metro Online is quite popular as well. Metro Online published this two defamatory articles about plaintiff business. Yeah, so these articles, these were the titles of the articles. Because of the publication of these two articles, the plaintiff's business has been adversely affected. Yeah? There has been lesser people seeking treatment at the Darul Saka, the Pusat Rawatan Darul Saka lah. So because of that, they have actually sued for defamation. Yeah? And the High Court basically decided that the defendants were liable for defamation. Okay, so those were some of the examples of cases. We know that the elements to prove defamation, there are three elements. First one is that the plaintiff has to prove. Apa tadi tiga elemen tadi? Plaintiff must prove that the statement is defamatory, that the statement is about or talks about, it refers to the plaintiff, and the third one is that the statement has to be published. The article or the statement too has to be published. So we know that publication, as if you talk about print media, publication is very clear. It's about sending the message out to the world, so for the third party to read. Yeah. But online, when you talk about the online environment, as opposed to the to the print media, if you publish on a print media, you will be able to determine who is the publisher. If, let's say, newspaper reports about a certain incident, and then turns out that the incident didn't happen and it caused shame on a certain someone, so you know who is the publisher or the editor of the news. You can find the person, and then maybe a correction statement can be made. But the problem with online publication is always about anonymity. So this was a hot debate back then in 2011, kalau tak salah 2010 ke 2011, in the parliament, whereby internet and anonymity is a problem, not only just for Malaysia but also for worldwide, because when you go online, people will not know who is the real you unless you declare your real name. Kan? So you, let's say on Facebook or on social media, you can use whatever name that you like. It is not a must for you to declare your real name on Facebook. And so a lot of people use funny names and or pseudonyms. So guna nama-nama macam-macam lah kan. Apa example of names. His real name is, for example, real name is Ahmad, and then he used his next door neighbor's name. So nama, not the real name. So this become when, let's say, when a crime happens or when legal suits occur, it's difficult to find. In particular, it's difficult to find who the perpetrator was, and then action. You want to take action against this particular defendant. It becomes very difficult. So because of that, the Parliament has decided, and this has been decided for the amendment to the Section 114 of the Evidence Act. This is particularly to cater the problem of online anonymity. Anonymous and being anonymous online. So you there's also a joke. Tak tahu lah kalau faham ke tidak kan. On the net, nobody knows you are a dog. So yeah, even with now, even a baby knows how to play with smartphones kan. So you tak tahu pun actually a baby is using a smartphone. So when the Parliament proposed for this amendment, it is actually an additional section 114 sub A. So this dia ada number 1, number 2. Tapi the one that we want to focus on is number 2. This is a person who is registered with a network service provider as a subscriber of a network service on which any publication originates from is presumed to be the person who published or republished the publication unless the contrary is proved. So this is the provision. The consequence to this is that in order for the consequence to this new provision, it basically shifts the burden of proof to the defendant to explain why he is not the maker of such defamatory publication. So Section 114A will assume, if it is applied by the prosecutor, for example, the Section 114A doesn't suggest that it only applies to crime. It can also apply to civil trials. So if, let's say, the plaintiff or the prosecutor wants to use 114A, the section will presume and a website owner or maybe intermediary or owner of a computer in which a publication is said to originate as the publisher of the publication, unless the defendant can prove otherwise. So remember, before there is a recent case, PP against MalaysiaKini.com. I think this is a recent case that you need to read as well. I think previously I have shared with you the case, isn't it? Saya tak pernah share. Attorney General Malaysia against mkini.com, Sri Berhad. So this case is a very recent case that our federal court basically explained the application of this Section 114. So I'm not trying to say that some kind of injustice happens here or what. No, you have to clearly understand how the context apply. Dia macam ni tau, Section 114A ni, it is not to be simply invoked by the PP, by the DPP. macam nak kasih senang kerja dia ke apa, tak ada tau. Before they want to invoke section 114A, usually there will be the PP will have to argue or to show to the court available facts that basically justify why we need to raise this presumption of publication. So example of facts are, when the identity of the real person doing the online defamation is difficult to be proven unless we raise this particular presumption lah. So here, when this section this section is created, when the court raises the presumption of publication to the defendant, it means now that the defendant has to explain why he is not the maker of the statement. So kan selalu kat Facebook page kan, kat Facebook page tu, kadang-kadang orang pakai nama pseudonym and other names kan, Abang Gagah lah, Adik Comel, tapi tiba-tiba dekat situ gambar, there is a picture of him there, saying a lot the defamatory words. So it is like, okay, it's because of the the difficulty of proving who is the real person online. Yeah? So section 114A basically raises this presumption. It's a rebuttable presumption, by the way, that now the defendant, please explain why this is not you. So the defendant, on a balance of probability, will have to explain why this is not him. As we will see in further cases after this, this is also a difficult presumption to rebut, because the defendant must raise the presumption up to a balance of probability. Kalau selalu in a criminal case, for public prosecutor, you must prove beyond reasonable doubt, but for the defendant, you must prove on a balance of probability. So here, most defendants, what they try to do in trying to respond to the presumption is that they do mere denials. They simply say, no, it's not me. Really, it's not me. Dia macam merely deny saja. Meaning, so the court does not accept the defense of mere denial. Meaning you must have something really concrete in order to in order to rebut the presumption. So it's basically a rebuttable presumption of publication, but it has to be proved up to the balance of probability. So that is, I have argued in some of my articles that this is quite a difficult threshold, but this has also been confirmed to be in line with the law by the recent case in the federal court, in the case of AG against MKinney, whereby the federal court has again reiterated that it is necessary to have this provision to solve the problem of internet anonymity. So this is really the court basically reconfirmed this. So so here people might say we are some commentators may say like we are assuming a person guilty even before he is proven guilty. Actually, that's not the case. Actually, it's a rebuttable presumption of publication. So it's on the defendant to explain why his name is there, why his face is there on the piece of publication. But imagine in a situation where the person is not so IT literate, and he will just say, no, it's not me, it's not me, it's mere denial, isn't it? Tapi dia tak ada apa benda lain nak defend, apart from saying it's not me. It's my computer, but I don't know how my face is there. So yeah, I guess that's a challenge as well, but the law has been designed in such a way. So this again will have to be determined by the with the the wiseness of the court to evaluate each facts carefully. Okay. So what happens next when let's say the plaintiff use 114A to presume someone as the defendant. So let's say if the defendant failed to rebut the presumption of publication, it will mean that he is the publisher of the said publication, and if it's a defamatory publication, then he may be found liable for the said publication. This Tong Siak Kan, the case of Tong Siak Kan, this was about online defamation suit, whereby defamatory articles were posted on 2 Google Blogspot website. It was hosted in the US. So after a lot of procedure, plaintiff applied for this John Doe action in the Superior Court of California. Yeah. So to basically why do they do this is to determine or to find who is the real defendant behind the blogspot. So when they have contacted the US court ordered Google to trace who is the person behind this blog, Google basically complied with the order and disclosed 2 IP address pointing to the defendants. Yeah? So here the first defendants, after being notified about this case, merely deny that he was the owner of the blog without producing a shred of evidence. So here on the balance of probability, High Court found that defendant failed to show any defense on the merits touching on the real matters in question, which is a substantive defense that he did not publish the defamatory statements, and High Court dismissed the defendant's appeal for the defendant's failure to provide any evidence on the balance of probability. This is one case lah. Okay. Right. Another case, National Union of Bank and Nurzila, was also about publication of defamatory statement on Facebook. So first defendant was merely denying that she published such defamatory statement and alleged that her Facebook account may have been hacked by someone. But nevertheless, she admitted to have published such defamatory comments in her statement of defense. Ini yang it can somehow confuse the court. But in this particular case, there was another case that was ongoing as well, PP against Rutinin. Because in Rutinin, what happened in Rutinin was that the court used or instructed the parties to do IP address check, which did not happen in Nurzila's case. So in this case, Rutinin was about this guy who posted defamatory statements on Sultan Perak's online visitor book on the homepage. Yeah? So as the case proceeds to identify the real identity of the offender, the court basically referred to the expert opinion of Cybersecurity Malaysia the court asked Cybersecurity Malaysia to conduct IP address check, and then which revealed the had identified the location and the internet address of the offender, and this actually pointed the gun straight at the defendant. So defendant had a hard time to argue whether he was a real person who posted the defamatory statement, and also merely denied to have done so. In this case, they use technology to try to pinpoint who is the real person. So as opposed to Norzila, dia tak guna that particular IP address check lah. So please read this case. This is also an important development in routine that I think for digital evidence, this is very, a crucial development as well. So in trying to determine an identity, the identity of a person online, it's not just Section 114A that can be used. You can use technological ways like, calling the Cybersecurity Malaysia, asking them to give expert opinion to identify the IP address, so they can basically advise the court. Okay, they have done some technical search and they found that this is the real computer that had done the said offense. But the only problem with this method is that they can only detect up to a point of the computer. They cannot know anything beyond that, up to dia boleh tahu komputer mana, but they cannot know who is the user who published the defamatory statement. This is where Section 114A complements the lacuna. Yeah, we may say that why not look whether there's a CCTV around. Yeah, what happens if there is no CCTV around? Itu yang 114A was enacted. Yeah. All right. Okay. Before I move to this part, any question? So we know that online defamation, there are three elements. First, you must prove that the statement is defamatory, and then the statement refers to the plaintiff. No problem about these two elements. Sama je dia punya application with the law of torts. But the third one, especially for cyber environment, there is this new development on Section 114A, as well as usage of cybersecurity as an expert opinion to determine how we can find the real culprit behind the screen. So Section 114A plus technology to help the court to determine who is the, or to try to solve the issue of online anonymity. So if the, yeah, sure, yeah.
What happened in cases where the content creator include a disclaimer? For example, they did the content for entertainment purposes without intending to cause defamation on the party. The elements of the online defamation fulfills, but the difference is that they include the disclaimer. Can the content creator still be liable?
Disclaimer. I think we see this a lot in movies. Kan? They put this disclaimer, nothing to do with real person. Yeah. But I don't believe that the disclaimer will simply lift their liability like that. So they can put some kind of disclaimer, tapi it doesn't mean that they are immune from legal proceeding. So
okay, thank you, Doctor.
Yeah, if they're being called to answer in court, they have to go and defend themselves. So yeah.
Sir,
Yeah.
I have a question. What if actually the defamatory statement maker is actually a child or a minor?
Then we also learned in let's say if the defamation concerns criminal defamation, then under criminal law kan ada certain provisions to allow this child to have a defense kan under dolai in capex and so on kan. So that will apply. That can somehow be a defense for the child lah. I think your point would be there are many child or children now having social media accounts, while the supposed age or the legal age for them to have an account is actually maybe 13 years and above. So what happens is that they have been faking their real age kan. Tu what you meant is Sarah. Is that what you meant, Sarah?
Not really. Maybe a child, but above 13.
So itulah kalau dia above 13, maknanya still within the definition of child, 18 years and below kan, meaning they can claim whatever defenses under the law lah that prevails at that particular point. So dia boleh kira macam a juvenile lah, for example kan. So the law applicable to them can apply. It doesn't mean they are completely immune lah. Tapi the problem is there's always a problem lah if the child does this, and then only later we find that actually it's not really an adult who does this, it's a child. So the law is there to facilitate this kind of situation. Kalau if it's a child offender under our procedure, boleh action can be taken against as well lah. Tapi I just like to expand a little bit lah, macam yang I explained just now. There have been many situations whereby now children they are exposed to all this channel social media semua ni, and the legal age for having a social media account usually is somewhere like, kalau tak salah lah, 12 years above, according to the policies of the social media companies lah. If you refer to Facebook, maybe 13 years age and above. So if the child managed to have an account, although he or she is actually just 8 years old, meaning he must have cheated his actual age. For that reason, Facebook even, they are not able to detect one by one because of the volume of accounts, not to mention fake accounts some more kan. So even I think we can see new games kan, games macam saya selalu sebut Roblox, apa yang budak-budak suka main ni kan. Roblox, for that matter, if you go and browse roblox.com ni, they basically collect personal data, personal information of those people yang main ni lah, including children. Because if you don't register an account, then you cannot play the game. So dia macam a lot of users are actually children, and tak tahulah apa benda dia chatting dalam tu kan, tapi dia playing games lah. So this is particularly problematic lah. It's a problematic area to determine whether this person is actually an adult or not. And this is why perhaps one of the reason 114 Section 114A of Evidence Act can assist the court to determine who is the real person behind the screen. So the presumption of publication as far as defamation or other kind of content is concerned, yang section 114A ni dia does not only apply to defamation, meaning other kinds of content pun it can apply. So the court will presume that the defendant is the publisher, but the presumption is rebuttable. It's a rebuttable presumption. So the defendant must show he is not the maker of the content or the statement. But there have been cases, as we have seen before, when the defendant try to defend himself, try to raise the presumption, they just give mere denials. They just merely deny. No, not me. So that is not enough for the court. It's not enough for the court. Okay, Sarah, okay?
Okay, but so if it turns out that it is confirmed that the child is the maker of the defamatory statement, then he would still be liable then.
Selalunya itulah, as a child, they under the law they enjoy certain defenses lah, which they can raise lah kan. So we have to refer to that particular law lah yang relevant. If we talk about criminal law, macam ni, for example, criminal defamation, the child perhaps can seek defenses, and if the court agree with this defense, the child may escape liability. But if the court disagree, liability may be imposed to a certain extent, like maybe giving a disciplinary punishment, kan? Sending the child to be under observation of pejabat mana-mana pejabat lah kan, and so on lah. So a child, there is a legal provision on child offender, tapi for civil matters jarang orang saman kanak-kanak kan, for civil matter lah. Nak kena check balik whether a child can be truly immune under civil punya ni lah. Kalau tak salah, yalah, selalunya civil actions ni people sue because they want compensation, kan? So if you sue a child, how will you be able to get the compensation, isn't it, from a child? Child might not have the money that you want, kan? So instead, maybe you sue the parents, for that matter, kan? So this depends lah on the case-to-case basis, whichever yang lebih realistic, kan? Okay, Sarah.
Alright, thank you, sir.
Afrina was saying something.
Yes, sir. I have a question. In a situation where people have been faking their identities, in the sense that they uses other pictures and others' name in publishing the defamation statement, and besides, they have been publishing the defamation statements through the computers located in cyber cafes, especially when the cyber cafes did not like record their personal details and whatnot. So how would the court trace the culprit behind the screen?
Yeah, I think that is really problematic for the court to find who is the real culprit. I think one thing, Afrina, the court can ask Cybersecurity Malaysia to detect which IP address is this coming from. That confirm that one memang tak boleh tipu punya IP address. So from there, Cybersecurity Malaysia can call. I mean, the police, katalah selalunya yang buat investigation ni police ataupun MCMC officer lah. From there, they can find the next steps lah, or the next trail Okay, let's say they found from the search, they found, okay, dekat rumah Taman Samudra. Okay, alamat nombor 3. Okay, tahu dah nombor 3. So they can find, they call everybody lah in who is in alamat nombor 3 to testify. From there, the the search can be further, be made more focused, and from the investigation, that is the traditional way of doing things lah. Maknanya you cari satu-satu. But if that doesn't work out, the evidence is not so good. It's not so convincing. So much so that the court is not convinced that this is the real person lah who did the crime, for example. Then meaning the prosecutor may not be able to reach the prima facie case, and the case will be dismissed lah in the, if the PP fail to have a prima facie case. So kalau evidence tu tak berapa clear, you cannot convict someone lah. As simple as that lah, Afrina.
Alright, noted. Thank you, Doctor.
Okay, so I guess I have to. Farhana wants to ask.
So what, sorry sir, what about if a person use VPN in order to defame someone? Because using VPN, a person can adjust their IP address. So what is the mechanism that will be used against that person?
This for those who does not know what VPN is, it's basically a kind of a application that is used to try to confuse the computer or the regulator, the network level too, as if you are not based in Malaysia. Your computer is as if it's not based in Malaysia, and therefore the regulations that is set by the ISP as far as content is concerned or network is concerned does not apply to your computer. So somehow you can bypass any blocking or any filtering that is being done at the network level. So ini nama dia VPN. Banyak orang pakai lah katanya untuk security and so on lah. So I'm not an expert in this kind of thing, tapi I have tried to interview officer from Cybersecurity Malaysia. They say that somehow you can use VPN. Susah sikit lah nak cari dia ni, tapi dia kata boleh cari. So according to the officer, they can still try to find, although you try to shadow yourself like that kan. Tapi a little bit difficult especially if the person knows how to hide himself. Tapi dia kata not many person actually are experts at this. So kadang-kadang macam you guna VPN yang tipu-tipu punya, simple aja dia nak decipher the codes tu. So this is beyond beyond cyber law lah, kena masuk kelas IT systems. So in a way, as far as the law is concerned, the courts are concerned, the courts will have to depend on the expert opinion from this MCMC or cyber security, where they will do their best in trying to figure out or trying to do this investigation. They will do their best in trying to help the court, especially the prosecution, to determine who is the person behind the screen. And kalau dia tak dapat jumpa, they will have to notify the court tak dapat jumpa lah. Tapi I think in many cases dia boleh cari tau. Macam we have our Facebook accounts and all these social media ni, they can retrieve so many information from our Facebook account. Sometimes we didn't even realize that much information that we are feeding to the social media on a daily basis kan. So yeah, I guess that's my answer lah, Nurul. So dia guna VPN. Sebenarnya Nurul, guna VPN ni, people have been saying whether this is wrong or right, but there have not been any prosecution over the usage of VPN. VPN can be used for positive things, for negative things as well. Kalau orang guna untuk security, for example, kan, that is for positive things. But there have been people who abuse this technology as well. So I think we can prosecute anyone who abuses the technology under Communication Multimedia Act. But there are not many cases. There are not many. Perhaps tak perasan. Rasa tak ada cases whereby people using VPN and they are being indicted. It's different with using the smart box, kan, TV IPTV, TV box tu kan. Those are different because those involve copyright infringement. So sebab yang mana yang guna TV box yang illegal tu, Android box kan, Android box. Yang mana yang illegal tu, they are actually in contravention of the Copyright Act. So action can be taken against quite immediately against the provider of the service. Selalunya police or the sebab benda ni guys, kalau tak salah saya, dia dah being declared as a criminal offence. So police can take action lah and go to your house and raid. Selalunya kalau tak salah Kementerian Dalam Negeri yang datang raid ni, KPDN KK kepenggunaan tu kan, consumer, KPDN
KPDN HEP.
the short form itu HEP pengguna consumer. They usually do these raids lah. Dia datang rumah, lepas tu dia confiscate and they will usually initiate proceeding against the operator of the box. Dia tak kalau nasib baik lah, dia tak saman punya yang owner tu, sebab dia akan cari sumber ni, dia akan disablekan sumber ni, and then everybody yang subscribe kat bawah tu semua tak boleh pakai. I guess Astro has been quite suffering from this lah, because people are buying some kind of packages online kan, and then they don't subscribe to the real service, so causing losses to the service provider lah. Tapi that's on a different note lah. Okay Nurul, sikit lagi saya nak habiskan, about 10 slides. Okay, so those were the issues of proving online defamation, the 3 elements. Now we will look at the issue of admissibility of screenshots. We do screenshots a lot now, isn't it? Our phones, even our PC are able to do screenshots. So orang suka lah ambil screenshots. Tengok ni dia kutuk aku kan, screenshot sub, 3 jari sub. And then you send it to people. There have been cases in courts whereby people try to use screenshots to prove that defamation has happened. Whether screenshots can be admissible as evidence in court. Boleh tak guna rasanya? Sebab nampak macam tak proper kan. Boleh ke screenshots is used as evidence in court? So there have been cases whereby attempts were made by parties to use screenshots to convince the court that this happens lah. So like example, Nur Azlan Shah and Muhammad Zihan ni, there is no steady trend towards a certain position here. It depends. If the parties wants to use screenshot, they have to prove that the screenshot is a good evidence. Dia tak semestinya, okay, you want to use screenshot, confirm this is a special treatment or a good evidence. Like any other evidence, if the parties wants to tender this as an evidence in court, they have to prove that this evidence is good and admissible. So those who will learn evidence law, you will learn this a little bit more deeper later. So for example here, defendant disputed the authenticity of the screenshots which contain the alleged defamatory Facebook posting. However, the court here refused to admit the screenshot as evidence because first, no evidence was led to the maker of the contents of this screenshot, and none were called to testify. No testimony as to how the screenshots were produced. And then there was no attempt to admit the screenshot under Section 90A as digital evidence. So maknanya the one who wants to use screenshots, they must prove that the screenshot is genuine to the court. How to prove that the screenshots are genuine? You panggil lah siapa-siapa to testify. You want to call engineer ke? You want to call anyone can be called to testify the genuineness of the screenshot lah. And in this case, that didn't happen lah. The party didn't call anyone to verify the authenticity of the screenshot. Sorry, dah hilang. Yeah, this one. And then, mana pula ni? In PP against the Green City International College, the court admitted and gave weight to screenshots of WhatsApp messages to prove a mala fide intent by a witness. In another case of Muhammad Azhar and Nazam Auto Trading, industrial court disregarded a screenshot of a WhatsApp message, WhatsApp chat. So this was about dismissal from the company lah. He allegedly sent threatening and harassing messages via WhatsApp to a colleague who then left due to the message. And claimant brought an action against the company for wrongful dismissal. So in this case, they tried to use what screenshot of a WhatsApp chat. Because of that screenshot, the person left the company. So we can see there's a different approaches. The court didn't give special treatment to screenshots. Maknanya kat sini, if you want to use screenshots as evidence in court, you have to prove the authenticity and the genuineness of the screenshots lah. Sebab apa sekarang ni screenshots banyak boleh tipu kan? People can edit screenshots, and therefore if you wish to use this as evidence in court, you have to prove the genuineness lah. In Godfrey and Demon, this, I think you still remember, this was, as far as defamation is concerned, ISP was considered a publisher in common law, although they are just a mere conduit. But the situation is different when it comes to Ban and Tilly, especially when the ISP is just performing a passive role. They are not to be deemed as a publisher lah. What about liability of administrator of an instant messaging application? Ni kena selalu guna macam WhatsApp kan? WhatsApp, Telegram. I think all of you must have been an admin of a group kan? A group assignment for IT law course. Siapa jadi admin? There has been an issue over whether the group admin should hold more liability or responsibility to monitor the content that goes through in the group. There has also been questions or MCMC. MCMC has issued advisory on what a group admin should do. Dia kata kat situ, group admin should not be a silent admin. group admin should guide the discussion so that it does not, it should stay on track. Jangan silent aja, biar kalau orang pergi, people are posting negative things in your group, you just leave it like that. So the question here is, does a group admin really have to monitor everything? Kalau you jadi group admin, you nak monitor semua benda tak? Nak tanya, sekejap je nak tanya.
Tak nak.
Tak nak kan? You tak nak monitor kan? Macam orang ni kata, I think we can find a lot of this in-house rules. Some groups, they try to create this in-house rule. This group is strictly for law society things only. No business advertisement, no politics in here, no this, no that. Tiba-tiba ada somebody posted about Datuk Seri Najib, blah 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 blah, ataupun party A, party B. Oh, somebody got angry, blah blah blah, blah. And then somebody left the group. I think we are familiar with this drama lah. So this is the issue lah, whether admin of a group shoulder extra liability. It remains, it's not clear whether they shoulder extra liability. There have been attempts by the MCMC trying to say that admin can be liable for under Section 233 as well. How far this is true is yet to be tested in court. So people can claim, oh, you are liable, under 233 because of the extensive nature of the provision. Tapi if it's yet to be tested in the court, we will never know whether this is true or not lah. So ni apa kata kat sini, unlike Facebook, admin of an instant messaging application group may not have the option to delete messages of their group members. An admin generally has the power to add or remove members. The power to control a group depends on the instant messaging application. For example, Telegram may mute the group, blah blah blah. Okay. Tapi we see that as time goes by, the policies of these instant messaging apps were being revised from time to time. So sometimes now, as for now, we know that macam WhatsApp, they are using end-to-end encryption. Using end-to-end encryption basically gives more privacy to the group members, in which the WhatsApp central to WhatsApp or Facebook as the owner of the product, they will not know what you talk about. They will not spy. That's what they say lah. They will not spy or what you are, what you are saying in the group, which can also raise a question whether you cannot sue Facebook for whatever illegal things that you do in the group lah. So maknanya sekarang ni mungkin bila dia dah buat end-to-end encryption, they are no longer they are clearly a mere conduit or a passive carrier. Sebab dia tak, memang they just provide the platform for you. I mean, whatever things you do in that group, you are liable as a group. That can be the situation lah kan. Okay, another issue on liability for publishing hyperlink on blogs. Yeah? There can be many hyperlinks on blogs. Yeah? Example, NST and Ahiruddin here. Applicants sued defendant for libel and malicious falsehood against respondent in relation to various articles which was published on this particular weblog. So during the course of the proceeding, parties they agreed, they give an undertaking to the court that they agreed that the parties shall not publish any articles, comments or posts regarding the dispute before the High Court that may be regarded as sub judice or they can be prejudicial to the fair trial which is ongoing. Applicants alleged that the respondents had breached the undertaking, it was contended that respondent was also guilty of contempt by maintaining a hyperlink to his weblog. So applicant alleged that the content of this weblog interfered with the course of justice lah. So applicant commenced contempt proceeding against respondent. So here High Court held that respondent could not be liable for the content of the weblog because he was neither the author or the publisher of the weblog. So here the weblog was an anonymous weblog. It was maknanya court is trying to say this is just a passive hyperlink. There is also 85 other hyperlinks that was attached together with the particular said link lah. So in this case, applicant failed to disclose a prima facie case for contempt of court. Yeah. So hyperlink, setakat letak hyperlink aja, and then there's a lot of other hyperlinks in the same page as well that might not directly make you liable. Kan? Okay. So again, that will have to depend. As I said, it's a question of fact. The court must evaluate on a case-to-case basis lah. So finally, on the remedy for online defamation, it's pretty much similar to remedy for the ordinary real defamation. You can apply for injunction to compel defendants to do certain things like changing the privacy setting, maybe asking the person to take down, you can also ask for a court order to require the defendants to disclose the identity of the recipient of the defamatory statement. You can, if you ask for this court order, it can be useful to determine the extent of the publication. So court can grant this order. Atau defendant kena buat lah. And then because the defamatory statement may be republished by other parties, you can also ask for court order requiring defendant to identify who had republished the defamatory statement. And then you can ask, directly ask for content deletion, or maybe publishing a clarification, or ask them to publish apology. You can also ask for the apology statement to be pinned. So ini kalau letak as a court order, they have to do it. Otherwise, then benda tu hilang sekejap je lah kan. Apologies, naik hilang kan. And then you can ask for damages as well, damages compensation. Okay, so conclusion here is that online defamation is not new, but when this happens online, it basically brings greater harm to the victims. So we, as far as possible, we try to make the cyber world, the digital world, a happy place to stay, to interact and to communicate. So I think try to avoid saying things or writing things which are not necessary. Sometimes lesser digital presence may be more peaceful for us. We have to try to balance this kan. Kalau everything that we do, we need to post, we need to write online. Kadang-kadang we are not happy with certain things, and then we comment online without knowing that can cause any particular consequences kan. So be careful of what we say online, because it's going to remain there forever, and we never know when those particular things is used against us lah. So with that is the end of the topic. Maybe just one or two questions if I can address. Yeah, Adenin.
So I have a question about the screenshot of fake news that would be spreading viral through WhatsApp or like other chat platforms. Would it be treated the same like the previous that you said?
would it be treated the same? Treated the same too? What do you mean?
I mean, like, for screenshots that you have to prove how it was produced,
Yeah.
to admit and to call someone to testify the evidence.
Yes.
So, but it's a viral, the anonymity of the fake news, like a screenshot of, for example, there's this COVID cure,
Yeah.
for example.
Yes. If you wish to admit that kind of evidence, the person who wants to admit that as an evidence in the case must prove the genuineness of the evidence lah. Screenshot, be it screenshot, be it a video. Kan sekarang banyak orang ambil video ke phone kan, video dia ambil video, and at certain point of time the video went viral. Nobody knows who is the maker of the video, but it went viral. So anyone who wants to use the video as an evidence in court must prove the authenticity of the digital evidence. So even for video, court will not blindly accept digital evidence. Sama lah macam mana-mana evidence, the attitude is the same. I mean the treatment is the same. Yeah? Okay, Adina?
Alright, thank you, sir.
In the next topic, we will talk about topic 8. I think topic 8. Next topic, we'll talk about cybercrime. Yeah, there are two parts to topic 8 because of the there's actually a lot of other two parts that I have divided by according to the slides lah. So next topic 2 we will talk about cybercrime. Topic 8 and topic 9 ada dua bahagian. So insyaAllah the next Friday we will explore on that. Okay, if there is no further question, let's call it a day. Take care and let's close with tasbih kafarah. Thank you. Assalamualaikum.
Assalamualaikum.